We've made it to the point in the lawsuit where we have some meat on the bones. So let's just go through what has happened so far. So far we've covered the beginning of a lawsuit, the complaint. I've been harmed, I deserve a remedy. We have an option for pre-answer motions to dismiss, which say in one form or another, the court should not hear this case to begin with. I'm not even going to argue the merits. We shouldn't be in court at all. Then we have the answer. The court has taken the case. Say your pre-answer motion got denied or you never made one. And there you have, I admit something, I deny other parts, or I have an excuse for some parts. We can amend, we can revise the complaint or the answer, and then we move into what we've just been covering, discovery, which is the longest and usually the most arduous part of a lawsuit. And you're asking yourself, what do I need to convince a jury or a judge that I'm right? And how can I get that information? Perhaps even more importantly, you're asking yourself, what do I need to convince my adversary to drop out or to settle? And how can I get that information? Because as a factual matter, as we've talked about a lot, you usually never get to a trial on the merits. Discovery, one of the things that makes discovery so important is that each party becomes aware of the strength of their case and their likelihood of winning. And that often pressures them or convinces them or makes it easier for them to settle and find a settlement amount that they can agree on. There are, though, other ways to end lawsuits. And today we're going to talk, or for our next class, we're going to talk about 3 of them. We'll spend the most time on summary judgment, which is the most complicated of them, and in some sense the most important. But there are other ways that are due to the litigant's own participation or failure to participate in the lawsuit. So let me just briefly introduce you to the first one, which is default. Default is when the lawsuit is dismissed because the defendant does not participate. So this is, again, as usual, not a decision on the merits. It doesn't say, yes, you did the thing that you are accused of, but it can impose liability because failing to participate in the lawsuit is kind of like admitting that you're liable. So it's a little bit like, remember in answers, if you don't address an allegation in the complaint, you are ascribed an admission, so it's as though you've admitted it. So if you don't address the lawsuit, in a sense, then we attribute to you liability. And that can happen for various reasons. For instance, maybe you didn't respond with an answer, or maybe you did file an answer and participated up to a point, but didn't comply with a discovery order or other court order. So you can see how default is both a way of dealing with defendants who simply refuse to participate, so that the plaintiff isn't hung up forever in litigation that isn't going anywhere. And also it's a punishment that hangs over the head of a defendant to basically coerce them into obeying the rules and doing what the court says. So if that happens, then the clerk has to order a default. And a default is an adjudication that the defendant has lost the case because they've defaulted. Default judgment, further, in Rule 55, is a grant of some remedy after a default has been granted. So if we know how much you are owed, so for instance, if it's a contract dispute with liquidated damages where you list the damages, or most frequently, if it's a debt and there's a promissory note saying how much the debtor owes, then the clerk can simply enter a default judgment for that amount. If it's something more complex that requires some judgment to figure out, like an emotional distress claim, then that's something the plaintiff works out with the court. The punishment aspect here for the defendant is that the defendant doesn't get to participate in that negotiation because they've defaulted. So in an emotional distress claim or something like that, you can see how it really works against the defendant's interest to default, because they're then not party to the decision about how much they're going to owe. On the other hand, in a situation where a person owes money and knows they owe money, and so they know they're going to lose in the lawsuit launched by their creditor, it might actually be quite rational to default. If you know you're going to lose and you know you owe the money already, then there's not a lot of benefit in spending the time, the money, the effort in participating in litigation when you don't have a viable defense. And in fact, a huge number of default judgments are exactly of this sort. They are creditors suing debtors who simply don't participate because there's nothing they can say. And the reason creditors do that is that the default judgment then allows you to take various kinds of coercive measures to get money from your debtors, for instance, garnishing their wages and stuff like that. But the debtor doesn't really have recourse there, because if they in fact owe the money and they know they're going to lose, there's no point in participating in the lawsuit. So sometimes default is a bad idea, but sometimes it's actually a very rational and economically advantageous, I guess you could say, or less economically disadvantageous course of action. On the other hand, Rule 55 also says that a court can set aside a default judgment for lots and lots of reasons, all the reasons listed in 60B. So I've written down those reasons for you, grouped in ways that make sense to me. So mistakes, new evidence, fraud, the judgment's already been satisfied, or it's based on another judgment that's been reversed. And look at these last two, is no longer equitable, or any other reason that justifies relief. And what you see here in Rule 55 and the way it relates to Rule 60 is that as a system, we really don't like default judgment. We want people to participate in the lawsuit. And if we can get them back in the lawsuit, we give a lot of leeway to courts to put aside the default and get at least an argument on the merits instead. And you can keep that in mind while you're reading the next case for default, because I think you see some of that there as well.